Hopefully you are here to listen to a webinar regarding drug testing and marijuana issues. Welcome everyone. This is part of CMC's series, and we try to do this about once a month to just inform you about the goings on in the labor and employment world. And Andrew and I thought it would be a very timely presentation to speak with you about what is going on with all the new laws and regulations regarding drug testing and marijuana issues. Please note that this webinar is being recorded and all your lines are muted. However, there is a chat function that should be on the lower left-hand corner of your screen in which you can ask questions, and Andrew and I will do our very best to address each of your questions as we can going through the webinar. For those of you who don't know me, my name is Jordan Schwartz. I'm a partner in the labor and employment practice here at Conn Maciel. And I represent employers in all aspects of the employment relationship. Specifically, I defend employers in really all matters relating to discrimination, wage and hour, family medical leave, really everything under the sun in terms of litigation. And I also counsel employers on compliance with state, federal, and local laws relating to all aspects of the hiring process, whether it's discipline, all aspects of the employment process, whether it's hiring, discipline. We do a lot of internal investigations, certainly advice and counsel on termination. I also advise unionized and non-unionized workplaces regarding employers' rights under the National Labor Relations Act. Also with me is Andrew Sommer, who will introduce himself.
Hi, my name is Andrew Sommer. I'm a partner at Conn Maciel Carey's San Francisco office. I represent employers in both Southern and Northern California on various employment-related issues. And so part of my practice is counseling on employment-related issues such as terminations, handbook reviews, reductions in force, things of that nature. And I also represent employers throughout California on individual and collective action. So that may involve a class action as well as an action under the Private Attorney General's Act, also known as PAGA in California, as well as individual actions. And my practice runs the gamut, everything from employment discrimination claims to wage and hour compliance to contract liability. I also handle CalOSHA claims, regulatory claims representing employers in that setting. I will now turn it over to Jordan to begin the presentation here.
Thank you, Andrew. So as all of you know, marijuana use and specifically how employers need to address marijuana issues in the workplace with all these new regulations coming at the state level is really a hot button issue. So as I said, Andrew and I wanted to tackle this issue and share our expertise and knowledge with you. But for the agenda, before we specifically get to marijuana use, we really can't do that without at least a little bit of a primer regarding traditional methods for employers tackling employee drug use and really procedures and processes for drug testing, so you know what is and what is not lawful, and so you have a basis and knowledge for what to think about in terms of general drug testing as an employer, and then specifically once you learn more about what's going on in the world of marijuana, how to deal potentially with drug testing and or employment-related decisions as they result from any of your employees potentially using marijuana. So first, I am going to start by speaking about the overarching questions regarding drug use as an employer? What are the main questions that you should be thinking about? And you might have various policies already in place. Hopefully you do. And hopefully you've taken into account both federal and state law. And since we have a national audience here and I can't go over every state, I'm going to just try to give you some broad strokes of the considerations, both from a federal and state law perspective, you need to be aware of when you're deciding either to create your policy, change your policy, or just check your policy and make sure you're complying with the law. I want to make sure you know whether you can, depending on where you're located, legally require current employees to submit to drug tests. A similar question that sometimes has a different answer is, as an employer, can you legally require job applicants to take drug tests? And the third issue I want to discuss is, if you can do either one or both of those, how can you ensure that you do not run afoul of the law? So in terms of the background here, as some of you may know, there is no comprehensive federal law that regulates drug testing in the private sector. When this issue has come before the Supreme Court has held that while drug testing may, in some cases, infringe on an employee's privacy, it also, in some cases, may be necessary in order to protect the health and safety of others. So they kind of have punted on the question of whether it's lawful or not, and says it really depends on certain factors. So instead, of a comprehensive regulatory system set forth by either the Supreme Court or legislature, U.S. legislature, federal law instead has provided for specific agencies or states to adopt drug testing regulations for employers under their jurisdictions. And from a federal level, that means that maybe the Department of, talking about the Department of Defense, they require defense contractors to set up procedures for identifying drug testing procedures. Similarly, if any of you are in industries regulated by the Department of Transportation, that too requires industries to regulate how to conduct random drug and alcohol testing, mainly for workers in safety-sensitive positions. And you're going to hear me refer to that phrase often in the next little while about safety-sensitive positions, because that's where some of your obligations will come about. Also, some of you may be familiar with the Drug-Free Workplace Act. And what that is an act that requires some federal contractors and grantees to agree that they will provide drug-free workplaces as a condition of receiving that contract or grant from a federal agency. And if you are a federal contractor, you may be subject to the Drug-Free Workplace Act, and as such, the act would impose certain educational and awareness requirements. Basically, it's known as establishing a drug-free awareness program. And the Drug-Free Workplace Act will also require you to publish and give a policy statement to employees informing them what is or is not unlawful, typically through your employee handbook that hopefully many of you, even without being subject to the Drug-Free Workplaces Act, have some sort of language that says the unlawful manufacture, distribution, possession, or use of a controlled substance is prohibited. So that's really the kind of broad brush regulations that exist from the federal government perspective. So then, just in terms of general more general concerns from a federal standpoint, and also these are also state concerns also, are just the general legal concerns that you need to be aware of. And we have this picture of this person juggling all these legal concerns when instituting or considering a drug testing program. The top one I have there is discrimination claims, and of course, any employer who could single out a certain group of employees for drug testing, whether it be by race or age or gender or really any other protected characteristic, certainly could face a claim for discrimination. And I'm going to talk specifically in a minute about claims under the ADA, which are the most applicable to this issue here. Also, you'll see I'll discuss there's invasion of privacy concerns, both at a state and federal level. You might also be wary of an employee who has a claim for defamation if you purposely or inadvertently publicize an employee's positive test result, especially if it is a false positive. And there's always just violations of specific laws and procedures about how the testing should be done. Many states have specific procedures about what you can and cannot do, so you really just need to be careful to specifically adhere to your state or local jurisdiction's procedures while carrying out drug testing. As I said, the biggest law that I want you to be aware of when you're thinking about the drug testing issues is the Americans with Disabilities Act. It's really interesting. The ADA does not consider drug use a disability. So, in other words, a person who is using illegal drugs is not a qualified individual with a disability, so that individual is not subject to the protections of the ADA. If you test someone for illegal drugs, since that individual, if he or she is using illegal drugs, is not protected under the ADA, the testing will not be considered a medical examination and also not protected under the ADA. But where you need to be careful here is that an employee who is undergoing treatment for drug use may actually be covered under the ADA. An individual who is a former user of drugs who is undergoing use is protected under the ADA as someone with a disability, and then if that individual can perform the essential functions of the job, you do need to engage in the interactive process with them, and I'll explain that quickly in a minute. So again, just remember the contrast where if it's someone who is currently using drugs, they're not protected under the ADA, but someone who has formerly used drugs may be protected under the ADA, and that's just a line that a lot of employers struggle with and is the genesis for numerous lawsuits under the ADA. And again, as I said, this is by far the most significant legal risk that I've seen when deciding whether to engage in drug testing, because if you decide to fire an applicant or an employee because of a positive drug test, and it's based on medication that was legally prescribed, possibly for some other type of disability, there is a chance that your company could be liable, because some medications do turn up on drug tests that otherwise would be illegal, but they are legitimately prescribed for certain conditions. So it's just a really, really touchy area of the law that I can't get into too much detail right now, but I just wanted to make you aware of the potential problems that can arise in the ADA context. And as I said earlier, I just wanted to remind you, for everyone on this webinar, about the way the ADA reasonable accommodation process works. And this is really for all aspects of individuals with disabilities, but even just in the drug using context. The three things I wanted to let you know, just so you could try to remember this going forward, is that the obligation to potentially reasonably accommodate an employee or an applicant applies right immediately from the application and hiring stages, as well as, of course, during employment. And what that means is that employers must endeavor to make reasonable accommodations to allow individuals with disabilities to apply and be considered for jobs, so long as the accommodation does not cause an undue hardship on the company. And this includes accommodations in connection with pre-employment drug testing process. So if an individual has not yet received an offer of employment but has applied and has requested some sort of accommodation for the drug testing process, you as a potentially hiring employer do have a legal obligation to engage in the interactive process with this individual. So with all that being said, after thinking about the ADA, which is the biggest federal potential discrimination claim, I now want to move quickly to state law and talk about it generally and talk about DC for a minute before I turn the presentation over to Andrew to give a much more in-depth time to specific California law questions that that we hear all the time. So basically, in a nutshell, under state law, employers generally have a right to test for drugs, but there's a huge caveat there, unless there is a restriction in state law. And I'm going to talk about just a few states in addition to DC and California, but for the most part, you will have to check with your legal counsel or with us or with anyone else after this presentation to figure out what the potential restrictions are in the state in which you operate. But for now, know that this is really an ever-evolving area of the law. And as the law on employee privacy and related issues continue to evolve, testing programs that are not explicitly authorized by law certainly could be open to legal challenge. And for that reason, you need to know if you're in a state that potentially only authorizes drug testing for employees in safety-sensitive positions. Or are you in a state that explicitly authorizes only random testing under certain circumstances? Or are you in a state that has no restrictions whatsoever, but even if you are in such a state, remember that doesn't really give you carte blanche to have no checks and balances about whether to test for drugs based on all those concerns I described earlier, discrimination, privacy, state law, procedure concerns. Again, many states have enacted provisions, imposing some type of restrictions. Whether it's reasonable suspicion or probable cause situations, some states impose restrictions on public sector employees but not on private companies, and almost all states mandate specific methods for the handling of specimens and the use of test results. And since I'm in D.C., and certainly some members, some in the audience are from D.C., I just wanted to touch quickly on D.C. law, although in reality there isn't much. There's actually more specifics in marijuana law that I'll get to a little later. But essentially, D.C. law does not really address drug testing in private employment. There's a few exceptions there for some entities that contract with the district. But so if you work for an employer who contracts with the federal government or with the district, your company must, in all likelihood, establish a drug and alcohol testing policy. But if you're just a private employer, drug testing is not prohibited or restricted, again, unless it violates some of the other legal provisions that I have discussed. So that's really what you want to know. If you work with the government or if you have some other contract, federal or state contract, then you have to worry much more about whether the individual is in a safety-sensitive position. Some other states I just wanted to talk about real quickly really focus much more on an employee's right to privacy. I know I've dealt with a few clients in West Virginia, and West Virginia basically says that drug testing is an invasion of privacy, so that's kind of the barometer. Then they do give some exceptions if it's based on a reasonable, good faith, objective belief, and if it's limited to employees whose job duties involve public safety or the safety of others. Massachusetts is similar. I've seen different cases in Massachusetts come out completely in different ways based on the job duties of the employee. If the employee was just a white-collar employee who sat behind the desk, privacy concerns carry the day. But if the employee was a driver or engaged in another occupation that posed a health and safety risk, the court found that courts have found that random drug testing policies were valid, and kind of the protection of health and safety overrode the privacy protections. So it's really depending on the state, it's kind of a case-by-case analysis to determine whether drug testing and the zero tolerance enforcement policy is something you really want to deal with going forward. With that kind of general background, I want to now turn it over to Andrew to give a much more specific and detailed analysis of the law as it stands currently in California.
Thanks, Jordan. And to piggyback to what Jordan was discussing, California has a right of privacy like many other states that's been the basis for a number of court decisions restricting the ability of employers to drug test in California. And so what essentially has happened in California is you have a number of court decisions over probably the last 30 years that have cobbled together different essentially philosophies on guidelines on what is permissible testing. And we look really at the different categories of testing. And starting off with applicant testing, California has found through these court decisions that there is a right of the employer to conduct post-offer pre-employment testing of either all employees or certain categories of employees. So you can't pick and choose, but you can conduct testing across these broad categories. And this testing may be required as a condition of employment, that they have to pass the drug test. And this is drug testing of all applicants, as noted here, for particular job positions. And the one caveat is you can't single out certain applicants based on protected characteristics, such as factors that would give rise to a discrimination claim. But looking at the testing, it's not just you can conduct this pre-employment testing across the board as to certain categories of positions. But there are also other requirements that have been found, including that you need to ensure that the testing is not too restrictive. So there's certain types of testing, whether it's a urinalysis, which is typically found to be less intrusive than taking blood, or other types of sampling. There should be certain controls to ensure chain of custody and safeguarding of this information, and that the testing is reliable. And so that's the law on pre-employment testing. But then another category is post-accident testing, and that has been recognized as well under the case law, and it has been recognized specifically in safety-sensitive positions. You can ask me what safety-sensitive means. There's no definitive meaning here, but typically what the courts have found is this would be a position for which there could be a significant risk of harm, injury, death as a result of being under the influence and performing a job, such as if you're driving an automobile. Well, that's a less definitive situation. But if you're operating heavy equipment, that's clearly a situation where it would be safety sensitive. If you're working in construction trade where you are involved with various different equipment that can pose risks of harm, that may be a situation as well. And as Jordan mentioned, this is really, this whole subject of drug testing is really case by case. The law is very fluid, and so I would strongly advise consulting with counsel. You can certainly reach out to us with any questions you have before making a determination in many of these areas. But in terms of post-accident testing in California, you focus on safety-sensitive positions, and the testing is only permitted after a fatality or serious accident. And then, like the pre-employment testing, you want to ensure that you're using the least intrusive manner available under the circumstances to test. You look at the type of testing. For example, if it's a urinalysis as opposed to a more intrusive method of testing. And one case in particular has required that employees have at their disposal counseling or treatment options without fear of reprisal. So it goes along with these testing options that you ensure that you have well-defined employment policy stating what your requirements are, and the option to pursue rehabilitation, of course, pre-accident, as an option. Other testing options recognized in California include random testing and reasonable suspicion testing. As noted here, random testing is very controversial. It has been, in many instances, disproved by the courts. But really, the analysis as to whether you can randomly test employees is really looking at the employer's important interest in that testing. Are you focused on safety-sensitive positions? If that's the case, you may have a better argument that random testing is permissible. I will typically advise to focus on post-accident testing for safety-sensitive positions, as well as pre-employment testing as being areas where you have much more security legally than in some of the other areas. The other option for testing, the other method, is reasonable suspicion testing. The difficulty there is what is a reasonable suspicion? It must be something that's based on objective facts, so you're basing it on an objective observation of the physical symptoms. Does it appear that the employee is under the influence? Or you're basing it on reliable and credible information provided by another source. And this option is preferred over random testing. The difficulty I found over the years is how can an employer be sure that the employee is actually under the influence? There may be a whole bunch of explanations for erratic employee behavior. And this is a situation that if it were to be litigated and result in a lawsuit, it may be that the plaintiff's lawyer can really scrutinize the explanation offered by the manager for requesting the testing and really challenge whether that supervisor had a legitimate basis to even request the testing in the first place. So if you are going to consider reasonable suspicion testing, you first of all want to make sure this is in your handbook in a defined policy, just like the other testing methods, but also have clearly defined parameters for when this testing is conducted and have some sort of vetting internally to make sure that the manager that is making this determination had a reasonable good faith belief. Other considerations in California involve drug and alcohol rehabilitation. Just like the ADA provides employees the right to leave or rehabilitation for alcohol or drug related conditions, California has a labor code provision that requires employers with 25 or more employees to reasonably accommodate any employee who enters a alcohol or drug rehabilitation program. Now, this provision has not been heavily litigated, but the intent appears to be that if an employee comes forward and wants this rehabilitation leave and is eligible, that it be provided, regardless of the fact that the employee is disclosing at that time a drug or alcohol problem. However, if you have a situation where an employee is being disciplined for being under the influence of drugs or alcohol in the workplace, that is likely not a situation where the employee would be eligible for rehabilitation leave. The intent appears to be to provide rehabilitation leave to an employee pre-incident, though this is an issue that should be assessed carefully with advice of counsel on a case-by-case basis. Another issue, too, like federal law, is that if an employer contracts with or receives grants from the state of California, California's Drug-Free Workplace Act applies, and the employer must certify that it is a drug-free workplace. And other issues in California, it's like the issues that Jordan was discussing earlier, is there is liability under California law for invasion of privacy, for example, or intentional infliction of emotional distress, for violating the employee's rights with respect to testing or a subsequent termination. There could also be a wrongful termination claim. There's a variety of different legal claims that could arise. Now, one significant consideration if you operate in San Francisco is San Francisco bans outright drug testing. And as a result, I tend not to see much drug testing conducted by employers in San Francisco. The only situation where an employer may conduct drug testing is where the employer has reasonable grounds to believe that the employee's faculties are impaired on the job, and this impairment must present a clear and present danger to the physical well-being of the employee or others, and the employee must have the opportunity to rebut the testing, and that this is testing that must be conducted by a state licensing facility or state licensed facility. So it's a very clearly defined exception, and this may be triggered likely by a situation where there's an accident on the job, and from the nature of the accident, the employer has a good faith belief that the employee is under the influence. It should be noted, however, whether it be California law or San Francisco law more specifically, there are certain federal requirements that would preempt these laws, such as standards developed by the Department of Defense federally or the Department of Transportation for certain drivers. Now, I'm going to segue into marijuana laws more specifically and how these laws interplay with the issues that we've already discussed regarding testing. Now, there's been a proliferation in recent years of various marijuana-related statutes and initiatives in these states. The first laws that were developed in this area related to medicinal marijuana. For example, California had for a number of years a law that allowed by prescription that individuals use marijuana, and there's medical marijuana dispensaries as a result throughout the state. We saw that trend in other states. So right now we have 29 states and the District of Columbia that have legalized marijuana, at least in some form. And we have a list of the states on this slide. What we have seen in more recent years is that a number of states, I believe, starting with Colorado and was it was Colorado, and it will come to me in a second, and one other state that first developed around 2012 the recreational marijuana laws, and that has changed the dynamic.
Yeah, I think Washington, Oregon, and Alaska, I think those were with Colorado, but Colorado was really the forefront.
Okay, and Colorado certainly has received the most press on this. The subsequent slide will address more specifically those states. And so it's created an interesting dynamic nationwide in that, starting with the medical marijuana laws, is you've had states developing their own system, permitting the sale, distribution of marijuana, subject to certain controls that arguably are not ideal, and that this practice is in contravention of a federal law. And so you've had this battle over the years. It's certainly going to be accelerated now under the Trump administration, with the federal government considering tamping down on this practice in the states. But then moving to the next slide, the conflict that we see is that marijuana remains illegal under federal law, but we have states that have legalized in some form marijuana use, whether as medicinal marijuana or for recreational purposes. So we have this direct conflict between the federal and the state laws, and we've had the courts working through this issue to determine whether there is a requirement for employers to accommodate medicinal marijuana or even recreational marijuana in the workplace. Now, just following up to the medical marijuana statutes, the common features are that, as many of you know that are operating in these states, is that the patients have a medical marijuana card that they receive from the jurisdictions that permits them to seek physician authorization to obtain and use marijuana for medicinal purposes. So it's typically a branch of state government that will issue for a fee these cards. And there's some states that have laws that prohibit discrimination against these individuals for using marijuana for medicinal purposes. And so, for example, Arizona, Delaware, Minnesota, and Rhode Island provide some protection for employees who test positive for marijuana use and have medical authorization. But they're the only states presently that currently include such explicit protection under their laws. One interesting case that came out in Rhode Island was concerning discrimination based on cardholder status. In that case, a grad student in Rhode Island sued the employer alleging discrimination because that grad student, used medicinal marijuana. And what happened in that case was the institution had withdrew a offer of an internship after the individual disclosed that he had a medical marijuana card or permit. And so the issue in that case was whether the employer could refuse to employ that individual because of the cardholder status. And this case was unique in that it presented the parties the opportunity to address head-on the anti-discrimination provisions of the state statute. Other states that have anti-discrimination provisions in their medical marijuana laws include Arizona, Delaware, Connecticut, Illinois, Maine, and Minnesota. So if you operate in those states, you need to be aware of that issue. But specifically for recreational use, wanted to segue into the 4 states that were at the forefront that we were talking about earlier. One is the Colorado and Washington were the first to approve by ballot measure recreational marijuana use, and those were enacted in 2012. They actually took effect in 2014, and in 2014 we saw the same type of measures in Oregon and Alaska. And so what those 4 states have in common with their recreational marijuana law is that that they allow certain quantities of marijuana to be possessed by individuals, and that the individuals must be at least 21 years old. All right, so the next laws or the next states that have enacted recreational marijuana use laws have been California, Nevada, Massachusetts, and Maine. And effectively, these states have treated marijuana use similar to alcohol use with an age of consent and certain restrictions, but on a similar level as alcohol. And now I'm going to hand it over to Jordan to, I have one more slide and then I'll hand it over to Jordan. So I did want to discuss briefly California law. California, although being a very employee-friendly state, to the great chagrin of many employers, has a favorable ruling on this issue that has essentially allowed employers to treat marijuana as an illegal substance and as the basis for hiring decisions. Now, California first enacted the Compassionate Use Act, that was in 1996, that permitted medicinal marijuana use under certain circumstances. There was a California Supreme Court decision that came out after that law was enacted, addressing the situation of an employee that was fired post-employment offer for a drug testing result that showed that that employee was using medical marijuana, or was using marijuana, and that employee subsequently disclosed that it was for medicinal use. The California Supreme Court in the Ross v. Raging Wire decision ruled that that the statute, or that the initiative, didn't state an intent to restrict employers in the regulation of marijuana use in the workplace. And the court, very significantly noted that the federal law made marijuana use illegal. And in that case, the Supreme Court essentially upheld the employer's decision to withhold the job offer on the basis of the employee using marijuana, and found that there was no obligation to reasonably accommodate that employee for the alleged disability. And subsequently, Proposition 64 was enacted. This was last November. And that initiative legalized marijuana for recreational use. And that initiative specifically carved into it an exception allowing public and private employers to enact and enforce workplace policies pertaining to marijuana. And my reading of that is that, consistent with Ross v. Raging Wire, that despite this new law legalizing marijuana for recreational use, employers may still conduct pre-employment testing for marijuana use and make decisions adverse decisions based upon that marijuana use. One issue that has arisen, though, in many states like California and Colorado and others where there is legal recreational marijuana use is whether to even test for marijuana use. And that's really a public policy decision. There are some industries where there's a shortage of employees, and there's a concern by employers if they test for marijuana use, they're going to find that many of the applicants test positive and have to withdraw the job offer, and that's going to affect prospects. So that's really a decision based on the industry. Certainly if you have safety-sensitive positions where there's a risk of harm that's rather tangible based on the work performed by the employee, that there's a greater interest and arguably need to conduct testing for marijuana use despite the recreational marijuana law. So now I'll turn it over to Jordan to discuss District of Columbia.
Thank you very much, Andrew. Before I get to D.C. and some other slides about marijuana, there are a few things I wanted to mention. First, I don't believe I mentioned earlier, but for those of you on this webinar that are going to want a certification from the D.C. SHRM about attending this webinar, right when it's over, I will put a link in the chat function on the bottom left-hand corner that you all can click on, and then it'll take you to a site where you can download the certificate, and that'll be available for 24 hours. So just make sure you copy and paste the link that I give you, and then you go and download it shortly, so you will have that. Also, there are a few questions that people asked about my portion of the presentation that I will address now before I get to some more marijuana laws here. And one says, can you give me an example of what the reasonable accommodation process would be in the drug testing process? And for that, the main one I've seen for a few different cases, the employers were found liable because they required a urinalysis and the individual had a disability and requested a different type of testing, either blood or hair. For whatever reason, they could not submit to the urinalysis, and the court found that they failed to provide a reasonable accommodation, or at least engage in the interactive process, and found the company liable. So, on the one hand, you want to have policies and procedures that you abide by, but if someone has a disability, you need to be open-minded about trying to find a solution. Someone else asked about methadone, and that's one of those drugs that may be illegal, but also an individual may be using it in a recovery program, and if that's the case, you might not want to have such a quick trigger and terminate someone based on a positive drug test for methadone before at least exploring the circumstances for that use. And finally, someone else asked, what if a person is a current user and you test and a positive drug test results? Then that individual says they want treatment. Can you simply terminate, or do you have to accommodate? And again, in that case, if the person is a current user and is not currently undergoing treatment, that person is not protected by the ADA, and you can simply terminate if that's the route you choose to go. Again, if anyone wants to discuss these issues in more detail, feel free to email Andrew or me. I will give you our email addresses at the end, and we're happy to discuss further. Also, we will email these slides, or if anyone requests them. That's another question. Okay, quickly, so I have a lot to cover here, and I don't want to keep you guys too long past the hour that we set for this. First of all, so D.C. Joined the fray along with some of the other states that Andrew mentioned about 2 years ago now. And note that nothing in D.C. law that now, so while recreational marijuana is lawful, nothing in the D.C. law requires an employer to permit or accommodate the use of marijuana in the workplace. And similarly, the law does not limit an employer policy restricting the use of marijuana by employees. So whatever your policy is in the D.C. area, you do not have to amend it to account for this recreational marijuana use law. This is more just of a decriminalization decriminalization law. However, the important thing I want to point out in D.C. is what is called the Prohibition of Pre-Employment Marijuana Testing Act of 2015. And what that is legislation that bans pre-employment drug testing. This legislation, specifically states that an employer cannot test a potential employee for marijuana use until after an offer of employment has been made. The act is unequivocal and does not provide for any exceptions. So even if you're hiring for a position that involves safety or security, whether it's the operation of heavy machinery, or even I get this question in D.C. a lot about the need to obtain a security clearance. Those are concerns for which, honestly, the applicant's usage of marijuana might be a disqualifying factor. Be that as it may, the applicant cannot be tested for marijuana use as part of the application process. You have to wait until after the conditional offer has been extended. So it really just pushes back the entire process. It doesn't prevent you from testing. It just prevents you from testing until a conditional offer of employment has been made. So if you are in D.C., this is very important, and I want you to be aware of that. But moving on, I want to make sure to get here for all of you on this call is, as an employer, you likely want to know, as it relates to marijuana issues, is it lawful to terminate an employee who tests positive for marijuana? That's really the most pressing question we get from our clients, and as all lawyers like to say, the answer depends. Although what I'm going to tell you is most likely the answer is yes, that most states do allow employers to prohibit the use of marijuana, especially if it's on your premises or if the employee is exhibiting any signs of marijuana use. So on your premises, during the job, or exhibiting signs of use. That's almost a no-brainer that an employer has the right to discipline as they see fit. The second bullet point there is that there also is case law supporting an employer's right to terminate when an employee simply tests positive. And that goes to this next key question here, which is, can an employer discipline an employee for use that is off hours and off site? And then, is it for recreational use, or is it pursuant to a valid prescription in medical marijuana states? And even in those cases, for the most part, courts in almost all states have held that employers may prohibit marijuana use in their workforce. And note that doesn't say workplace. It basically, almost all courts, not all, but almost all, have said that an employer should not be forced to accommodate marijuana, and this slide just has a few random samplings from a few states, and the next slide has a few more from Montana, New Mexico, Colorado. You'll see most of these states are from the West, where there's more developed case law. And I am going to talk just for a minute about this 2016 Colorado case here that says employers are free to prohibit use and can discipline or terminate for a positive drug test. And what that relates to here is what some states have, which is statutes for lawful off-duty activities. And typically, lawful off-duty statutes are laws that are aimed at protecting employees' right to free speech. In other words, they were enacted so an employee could not be fired for engaging in political activities that their employers could disagree with. But those statutes also do apply to personal and lifestyle decisions, including marijuana. So if you're in a state that has a lawful off-duty activity statute, you need to at least be aware that taking an action against an employee who tests positive can run into an issue with this lawful off-duty statute. So just be a little careful when penalizing employees for off-duty marijuana use. And this came into question a couple years ago in Colorado, where the question for the court was whether the employer acted lawfully, in this case the employer was Dish Network, when it terminated the employment of a quadriplegic who suffered from debilitating muscle spasms, but he possessed a valid medical marijuana prescription. And what the lower court in Colorado found, and then the appellate court, and then the state court, the state Supreme Court, all found that the employer did act lawfully and it was entitled to enforce its zero-tolerance policy, even though marijuana was explicitly legal under the state law. The court found that marijuana usage could not be considered a lawful off-duty activity because under federal law, marijuana is an illegal controlled substance. So that's really where the federal illegality of marijuana trumped the state's legality of marijuana. So I don't know if I was surprised by that decision. I thought it was going to be a little more kind of hemming and hawing, but it really came out pretty strongly for the employer. So given that that's in Colorado, which has really been at the forefront of these laws, the ruling here has strengthened the right of employers in all states to continue to enforce zero-tolerance drug policies. That being said, as the author of this presentation here, I still want you to be careful, and I want you to reassess blanket bans on marijuana use, and at least consider the need to revise policies, at least as it relates to prescription drug use, because I wouldn't be surprised if at some point an employer has another case similar to this Coates case, and the court does come out on the other side. It hasn't happened yet, but this case is only only the law in Colorado, and while it's good guidance, it could really it could end up the other way, and I would hate for someone listening to this presentation to rely on this case and end up on the hook for enforcing a zero-tolerance policy if they're otherwise, if they made a decision that it wasn't in the best interest of the company. And that's where I want to go here, just to finish up a few more slides, and then I'll get to a few more questions and then get you the certificate. As an employer, when you're deciding what to do with these, this patchwork of marijuana laws, for a second, forget about the legality, forget about Andrew and me giving you the law, and just think about some practical aspects as an employer. As we've said, you can enforce a zero-tolerance policy in most situations, but will that reduce your pool of qualified candidates are so many people using marijuana either medicinally or recreationally that it otherwise will impact your workforce? And if so, what do you want to do about that? On the other side, will failing to test for marijuana, can that possibly increase workplace injuries or absenteeism, or potentially increase the chance for an accident and then potentially make you more on the hook for negligent supervision? That's another practical aspect to consider. As is, will treating marijuana differently than other illegal drugs create problems in your workforce? After considering those, I just want to end here with a few action items. Of course, you want to review your company's drug testing policy. You want to make sure that the type of testing is permitted under applicable law. You want to limit the intrusiveness of testing to get rid of any potential privacy concerns as best you can. You want to use consent forms. And, of course, you want to adhere to a consistent policy in responding to positive drug tests for employees or applicants. Certainly, you want to communicate your expectations with employees. Any steps you can take to diminish an employee's privacy expectations would be great. And I've set forth one example here by adopting a written policy explaining when drug testing will be required. It's always really crucial, I tell all my clients, to have written policies and procedures. And always, it's so important to train your HR and your managers on these policies and procedures, so when employees ask questions, you get consistent responses and everyone is on the same page, and so they can understand the types of drug testing that's permitted, they can understand the procedures, and they can understand employee disclosure requirements. Here is the contact information for Andrew and me. Feel free to send us an email, give us a call, and we can talk about these issues. I have just posted.
Jordan, I did want to answer one question. There was one question here about
yes,
how does
please.
an employer address all...
Before you answer that, Andrew,
okay.
Let me just tell everyone I just posted the link for credit. So if everyone can see that and they can if anyone has to run, please click on that link so you have that. And yes, and then Andrew and I will respond to the last few questions that are here.
Right, there was one question that was, how does an employer address all of these changes in the employee handbook? And that's a really good question because under many state laws, such as California, where there's a right of privacy, the courts have found that if you, in order to minimize the intrusiveness of the testing, the drug testing, that you need to ensure that you've placed employees on notice of the employer's requirements, in addition to ensuring that you're using the least intrusive means possible for the testing and having appropriate safeguards. So, it's really behooves employers to have a clearly delineated policy that states the type of testing that can be done, the commitment by the employer to prevent the use of illegal drugs and alcohol in the workplace. Even before developing that handbook, the most important thing you can do is really think through these issues and develop a clear idea of how far you want to take this. And every employer is different in the type of testing they want to conduct. And all of that just needs to be hashed out internally with a clear policy statement in the handbook.
Thank you, Andrew. And I see another question that says use in the workplace is not the same as having marijuana in your system, which results in a positive drug test result. Can you terminate for a positive test even if the person did not use in the workplace? And I don't know what state you're in, but for the most part, from what we've seen from the case law, the answer is yes, and that's what happened in that Colorado case, that Coates versus Dish Network. So that is likely lawful, and then it's up to you as a company and what your policy is to decide whether or not you want to terminate for a positive test, even if the person did not use in the workplace. And as someone else points out, marijuana does stay in your system for a while, so sometimes it is difficult to tell whether the use occurred in the workplace or not. And I have seen situations where after a positive test, you do interview the employee and talk to him about it and find out, to the best you can, whether the use did occur in the workplace or not. And once you know that, you can make an informed decision about how you want to proceed. As I said, Andrew and I are always happy to answer questions. Please feel free to reach out to us. And if we don't hear from you in a few weeks, I believe it's June 8th is CMC's next webinar. I will be doing it along with Lindsay DeSalvo on the changing landscape of anti-discrimination laws. And I hope to see many of you there. And feel free to check out our blog in the meantime, employerdefensereport.com, and let us know any input you have. And I will post, someone said they did not see the link to the certificate. I will post it again. Everyone should have seen it. And with that, I am going to stop the recording and end the webinar. Thank you so much, and we will, if anyone wants to email us, we will respond and give you access to the slides if you'd so desire. Thank you.